Greetings all. Have you ever wanted to give a marriage in your D&D game but weren't sure how to go about it? Or more likely, have you ever had a court case in your D&D game and weren't sure how to go about it? Well, I have good news for you. Today's delve into the medieval world brings up both. It's a 2-for-1. A buy one, get one free. But seriously, stick around and we'll look into the 1366 dispute between Redyng v. Boton, what marriage looked like, what the court process looked like, and the role disability played in it. Because yes, I somehow roped disability into this one too.
So the question here is, how is marriage any different? I'm ex-clergy, right? And it doesn't seem to have changed too much to me. Do we really even need a video about this?
Well, marriage in the 13th to 15th centuries really wasn't like it is today. I mean, really wasn't. In many instances, a marriage contract could be a simple exchange of words, as in, I take you as my husband, stroke wife, in front of witnesses or done privately, and this was enough to satisfy a simple marriage contract. If made with a future commitment, such as I will marry you, followed by an act of intercourse, it is also counted as a valid marriage contract.
What in the name of all that is sacred? Do you realize if that were true today, there would be many, and I mean many, teenage marriages?
Well, in the medieval world, there are two kinds of marriage. There's the canonically valid marriage, where vows are given in front of a large crowd and usually in a church. And then there's the clandestine marriage, which could be done anywhere. It could be in private, it could be without witness, or even without ceremony.
All right, so that's like common law marriage today. I get that, but why does this matter in D&D?
Why does all this matter? Well, for one, having your D&D characters get drunk, promise to marry some farmer, proceed to forget about it, and then realize sometime later that they are married, it's a great story hook in my book. Especially if said farmer is taking them to court to force that PC to hold up their end of the marriage. That's D&D drama at its finest. But there's also a medieval court case I want to talk about, and it falls into this clandestine marriage category. To quote directly from the Medieval Disability Sourcebook, Redyng v. Boton took place in July 1366. Alice Redyng of the village of Skameston appeared in the Consistory Court of York to claim that John Boton, a chapman of Skameston, was her husband. John denied the charge. During July of 28 to 29, Alice submitted the reasons for her claim and produced two anecdotal eyewitnesses to testify on her behalf, including a local beggar named William de Birdshaw, who claimed to have overheard the marriage contract and dispute. Now, pay attention to Birdshaw here. He will become very important later.
Okay, so wait a minute. A nosy bum was a witness? I have to ask this question. What does a medieval court case even look like? And if they didn't have any eyewitnesses, how could someone defend themselves in court if they wanted to keep their marriage? I mean, Alice seems kind of screwed here.
Well, paradoxically, canon law demanded a minimum of two eyewitnesses to a contract, and without them, no matter how obvious the existence of a contract, the court could not decide in favor of the plaintiff. As I'll remind you, Alice produced two eyewitnesses to the alleged contract. So let's take a moment to run through what this court case looks like. Quoting from the text, a marriage case was properly begun with the publication of the libel, or what the plaintiff sought of the court and why. The defendant was then offered the opportunity to submit exceptions or a response to the libel. The plaintiff then submitted articles, specific arguments which outlined what they intended to prove and how. After the articles were published, the defendant submitted interrogatories, questions they wished the official to put to the witnesses being questioned. The goal of the interrogatories was to answer any inconsistencies or disagreements in the eyewitnesses' testimonies. The articles and interrogatories were put to the witnesses, who would be questioned individually by the official of the court. The record of their testimonies, the depositions, were then published openly in the court along with the court ruling, end quote.
Man, this already sounds like a wild court case. So, how would we use this in our D&D games?
Well, I think that's a great question. I think we should cover the game mechanics before we delve any further into the example here. As I laid out above, a D&D court case could start with the libel, where, unlike today's court, it did not have to be a case of written slander. So, with the libel in hand, the offended NPC, let's say, brings the charges before the court. Then, the PC submits their exceptions, presumably that they are not guilty of the charge of marrying the dirt farming peasant, to use the earlier example. The PC should also select witnesses that can speak on their behalf. Remember, a witness's character is just as important as their relevance in a medieval court. So using other player characters as their witnesses probably wouldn't work, because they wouldn't stand out within the community. They would have to find members of the community. That said, the witnesses will support the defendant's side of the story. The NPC then brings forth the specific arguments that will prove the PC guilty. I saw you marry my daughter, etc., blah, blah, blah. These are the articles. The NPC will also submit the interrogatories, which are the questions that they want to ask the witnesses to the judge, at least at this time. Then the court case could be handled in really one of two ways. One, you role play out the whole event of Q&A with the members involved, and no dice need to be rolled. Or two, you determine the results by a combination of intelligence, wisdom, and charisma-based checks to determine the success of the interrogatories and the witness's response. The judge would, of course, side with the succeeding side, the side with the most successes. Whether you want to treat this as a 4th edition skill challenge, where you need, say, 5 successes before 3 failures, or whatever, that's up to you and your hobby. Now, you could do a mix of these, allowing, bonuses for good role play, but in my experience, the best role players are often betrayed by their dice at times like this. So, all right, with a gamified court system in mind, let's actually look at what happened with this court case of Redyng c. Boton. After bringing the false marriage charges forward, John argued that Alice was of quote-unquote servile condition and did not have the authority to conduct marriage vows, and her witnesses were unreliable. All right, that's the core of his argument. One of the two witnesses, and really the only one we're going to be focusing on, was William de Bradshaw, or Brideshaw, however you want to pronounce it. He was a town drunk, a fool, quote-unquote, who overheard the ceremony but was not aware Alice and John were getting married at the time. While I won't go into the whole court case, because really we'd be here forever, I will say John's case rested on trying to discredit Brideshaw as mentally incompetent.
Okay, so he overheard the marriage. I would love to know what that meant. But you mentioned disability before. Where does that come into play at? I mean, being stupid isn't a disability, is it?
Well, the nature of disability is of interest to this case. Brideshaw was an alleged alcoholic, indolent, and held in mente captis, or of captured mind, roughly translated. My Latin is okay. Put simply, John's defense tried to argue that Brideshaw was unfit to a vague mental illness, a lack of moral character, since he had effectively to beg for money when he couldn't work, probably due to his arthritis. Once again, it was only during the cold months that he couldn't work, but that's speculation on my part. But he also had this, of course, bad habit of being drunk, which could make his testimony very unreliable. And in quoting from the text here, mental capacity and impairment exist along a spectrum, such that it is possible for William de Brideshaw to be mentally impaired in some way while still being perfectly competent to depose, end quote. So if John could successfully discredit Brideshaw, Alice would only have one witness and her case would fall apart, because medieval courts require a minimum of 2 witnesses. So let's push up our glasses, grab some tea, and look at this as a specific example before we conclude this video. This following section is from the latter part of the trial, where both the plaintiff and the defendant are summarizing their stances before the final ruling is made. We're going to start with the plaintiff's side and then move to the defendant's side. But I want to be clear here. The language here isn't clear, and they don't break up who the defendant and who the plaintiff's side is. I do speculatively, but really it's not broken up here, so I'm just going to read you an excerpt from the whole thing, and you can sort it out on your own. So this is from Membrane 11, Recto and Verso, Petition to Present Deponents, Pro John Boton, September 24th, 1366. Skipping all the forward legalese in God we trust stuff. It states, and by others, as much as by said Alice and her adherents in this party, at no time was it believed or in any way said or aforesaid, because William de Brideshaw is a witness notoriously suspect in said cause, and for and from that fact, the same William at all times of his reception, deposition, and examination in the said cause, and before and after, was to this point a pauper, and notoriously deposed of poverty, who sought his bread by begging door to door. And at all the said times, the said William was, and to this point notoriously mente captus, caught in the mind, and in no way had natural discretion, but because of gifts and promises to him by the said Alice and her party, corrupted and informed, he gave and put forth his false testimony in the said cause. And the same William was at all the said times of bad fame and conduct, and of dishonest reputation, as such a one who was willing to speak carelessly and to bear false witness, who was easily able to be corrupted and informed to false speaking by the said Alice, and to put forth false testimony in the said cause, just as he was in reality the same cause corrupted and informed as was put forth. Now for where I think it switches to Alice's side, but once again, it's not clear. And the said Thomas, sir not appearing in this film, desiring the promotion of the said consanguineous Alice, said and brought forth in the said cause his false testimony, and the same William de Brideshaw and Thomas were held as such men as above specified, at the said times were publicly held in repute and reputed at the present. Upon these things in the diocese of York and nearby places the public voice am labored and laborers, therefore the said procurator named above seeks in this course of law, by testing the words and depositions of the aforesaid witnesses as to the nature and quality of the promises, that they be weighed and demanded to be nothing, or to be cited as little or no faith, and further to be valued according to the nature and quality of all the same things, which is just. And it goes on.
It's medieval law and order. Dum dum.
Well, the long and short of it here, I'm not going to bore you with any more legalese, is that John failed to convince the judge of Brideshaw's unworthiness and was forced to accept the marriage and to cohabitate with his new wife. Alice manages, albeit off-screen in this instance, to convince the judge of Brideshaw's good character. In other words, he goes to church, works when his joints will let him, and proves that she hasn't given Brideshaw any money or food in exchange for his testimony. Again, his testimony, which is to say that he overheard the marriage, but he wasn't invited to the marriage, is less important than the actual moral character of Brideshaw himself. In other words, if he's a good person and has something relevant to say, the court will listen to him. Case closed. This case represents not only a win for disability in a medieval context, but also a clear demonstration that a person may be less than, quote unquote, in other words, disabled in one aspect, but perfectly, quote unquote, able in the other.
You know, this would make for one whale of a Lifetime movie original.
Well, it's also of note that alcoholism wasn't considered a disability, as it is today, and did not really weigh too heavily against Brideshaw's character. While he was othered for his quote-unquote mente captus, whatever he meant, but whatever they meant by that, he was seen as a capable witness in a legal sense. Court cases involving the poor are rare, and this case shows that your D&D players wouldn't need to know a wealthy or important person to defend themselves in a medieval court. Woo! All right. Well, I hope this video gave you all something to think about.
This was completely insane. I would have paid money to sit in that courtroom during those hearings. But you know what? Don't be insane like the court system and smash that like and subscribe buttons. If you don't, remember, we are the two witnesses that heard you say you would.
Tune in next week where I find something else to blather about, and until then, take it easy.